you have missed the questions. So they were all fully geared up to first have the questions so that it can be taken up. As usual, the first question would be taken by Mr. Prem today, and then Mr. Shyam, and then third would be taken by me. And today's formal introduction would be by Mr. KVJ Rao, an aviation expert. And then we will request Justice Ramkumar to take things forward. Over to you, sir.
Thank you, Vikas. Evening, everybody. It gives me a pleasure welcoming you all to hear this.
So volume at your end.
Full, sir. My volume is full, sir.
Okay.
You can hear me?
Yeah.
Yeah, okay. It really gives us a pleasure to interact and hear Justice Ramkumar. I mean, he's a doyen. He has vast treasure trove of knowledge, and I mean, to put words to introduce himself is very difficult to find those words. However, it is always a pleasure learning from him, and the good thing about him is he's willing to debate and discuss and address issues, and that is the most important thing. And I once again hand over the platform now to Justice Ramkumar, and let us hear it out, sir.
Thank you, Mr. KVJ Rao. Good evening, friends. Many of you may be wondering as to why such an elementary topic has been slated for discussion today. I know that even Mr. Vikas Chatrath must have entertained a feeling that a topic of this nature was unnecessary, although he might have been reluctant to put it straight to me. But I am sure that...
Sir, I'm just reminded that back to roots.
But I am sure that after this session, at least some of you will be convinced that this lecture was fully justified. I begin my lecture with the usual prefatory statement that I may not be treated as an expert in this branch of law. I am only a facilitator interested in sharing his knowledge and experience with you in the hope of only to rekindle your dormant thought process so that I can also learn many things from you. As every teacher, whenever he teaches, he also learns the law, learns the subject. As I always used to say, any law is better understood when actually applied to concrete fact situations. That explains these questions. Friends, the expressions trial and criminal trial continue to be baffling conundrums, which at times puzzle the bench and the bar alike, beside the academic intelligentsia. Anyway, let us try to see whether we can understand more of the subject. Shall we go to the questionnaire?
Yes, sir.
First question.
Yes, as Justice Ramkumar said, this is just dealing with a particular word, trial. What is trial? And all of us would think it is very, very, very simple. But in fact, it is not. Because this particular word that is having meanings, I mean, different texts in different contexts. And that is why it has not been purposefully defined.
Exactly.
The interpretation clause also, it is not there. And we have seen the decisions right from State of Bihar versus Ram Naresh, the 1957 three-judge bench, up to the latest Vinubai Haribai Malavi of 2019, another three-judge bench by Justice Nariman, saying what exactly is a trial and from which particular juncture trial commences. Anyway, to deal with the subject, I would ask the first question to Justice Ramkumar, sir. The first question is, what is trial in the context of a criminal case?
As rightly mentioned by Mr. Prem, the Code of Criminal Procedure 1973, which is our present CRPC, does not define the expression trial. The Code of Criminal Procedure 1898, which immediately preceded our present CRPC, also did not define the expression trial. But the Code of Criminal Procedure 1872, that is Central Act 10 of 1872, did define the word trial as follows. Trial means the proceedings taken in court after a charge has been drawn up and includes the punishment of the offender, It includes the proceedings under chapters 16 and 18 from the time when the accused appears in court. This was the definition attempted in 1872 code. But this definition was to be strictly, if you strictly apply this definition, then every proceeding after the appearance of the accused and the framing of charge leading to the acquittal or conviction and punishment of the accused would be trial. Then such a definition, if driven to its logical conclusion, would even include a conviction recorded and punishment imposed on the accused consequent on his voluntarily pleading guilty. But does it involve a trial in a case where he voluntarily pleads guilty? The court straightaway convicts him and passes an appropriate sentence on him? I don't think so. No wonder the 1898 code as well as the present code of 1973 did not choose to repeat the earlier definition of the word trial. But instead of attempting a proper definition of the word trial, these two codes in fact dropped this definition altogether. Then we may have to go to some other statutes to find out what exactly is a trial. Section 2(7) of the Banker's Book Evidence Act 1891 defined the word trial as follows. Trial means any hearing before the court at which evidence is taken. This is also not very helpful, but then it only indicates that trial takes place before a court and before which evidence is adduced. Even though the CRPC does not define the expression trial, there has been an attempt to judicially define the said expression. In Union of India versus Major General Madan Lal Yadav, 1996, 4 SCC 127, a three-judge bench of the Supreme Court observed as follows. It would therefore be clear that trial means an act of proving or judicial examination or determination of the issues, including its own jurisdiction or authority in accordance with law, or judicially adjudging the guilt or innocence. Judicially adjudging the guilt or innocence of the accused, including all steps necessary thereto. This definition was approved in paragraph 30 of the Constitutional Bench decision in Hardeep Singh's case, Hardeep Singh versus State of Punjab, 2014, Volume 3, SEC 92, corresponding to AIR 2014, Supreme Court 1400, 5 judges Constitutional Bench, rendered by Dr. Justice V.S. Chauhan. But Madan Lal Yadav, the three-judge bench, had gone one step further to say that trial commences the moment cognizance of the offence is taken and process is issued. This extreme view was disapproved by Hardeep Singh in para 35. That is where we stand, trial. So trial, in the absence of a concrete definition, we are left to the judicial interpretation of the word trial. Shall we pass on to question number 2?
Yes, sir.
Yeah, Shyam.
So usually the problem I think arises from the fact that we are so used to the term trial in civil proceedings as starting of evidence. When we produce a document, we'll write at the end. The original will be produced at the time of trial.
Yes.
Meaning that in the eve of tendering of evidence, or the matter is listed for trial. That means witness should be ready. I think that might be the reason why so much of confusion is being there also. So the question would be, the Criminal Procedure Code, which does not define the expression trial, however, defines the expression judicial proceeding under section 2I as follows. 2(1) says, judicial proceedings includes any proceeding in the course of which evidence is or may be legally taken on oath. Is not a magistrate recording a confession or a statement under section 164 CRPC conducting a judicial proceeding as defined under section 2I of CRPC.
So going by the definition of judicial proceeding, it includes any proceeding in the course of which evidence is or may be legally taken. So the question is whether 164 proceedings before a magistrate, a witness or a victim is sponsored by the police before a magistrate for recording his 164(5) statement, or an accused voluntarily goes to the magistrate and offers to make a confession. He need not be sponsored by the police, as you know. Then a magistrate recording a confession or recording a statement of a witness, is he conducting a judicial proceeding? Is our question. You will be tempted to say that it is a judicial proceeding, but no. A magistrate acting under section 164 CRPC during the stage of investigation is not acting as a court, and therefore the recording of confession or statement is not done in any judicial proceeding. At that stage of investigation, such person cannot be strictly called an accused or a witness, and there is no trial of a fact in issue or a relevant fact. In fact, as you all know, evidence can be adduced only regarding a fact in issue or a relevant fact, as declared by section 5 of the Evidence Act. It is not done either of these things when a 164 statement is recorded or a confession is recorded. There's a beautiful decision by a full bench of the Bombay High Court in Emperor versus Purushottam Ishwar Amin, 1920, ILR 45, Bombay 834, full bench. Then, where it was held that a statement recorded under section 164 CRPC is not evidence in judicial proceeding. Then the classic decision, Nazir Ahmad versus Emperor, AR 1936, Privy Council 253. In paragraph 12, the Privy Council held that the magistrate exercising power under section 164 CRPC is not acting as a court. Then there are other rulings also, AR 1963 Allahabad 308, again AR 1964 Allahabad 290, a full bench of the Allahabad High Court presided over by Chief Justice Desai. A beautiful decision. I am thankful to Mr. Prem Raj for once giving this citation. He had one occasion to give me this citation. The full bench decision is rendered by, the judgment is rendered by Chief Justice Desai. Beautifully explained why it is not a judicial proceeding. Recording of confession. Yes, shall we go to question number 3?
Yes, sir. Normally, while you're remembering, they say that you should remember by mnemonics. So here it is, they say it is IIT, that is investigation, inquiry, and trial. What is the difference between the three?
Yes. Now, section 2H of the CRPC defined the expression investigation, which includes all proceedings under the CRPC for collection of evidence. That is investigation. The definition of inquiry under section 2G CRPC is not very helpful, since it means inquiry means every inquiry other than trial. That is not at all helpful. A trial cannot commence as long as an investigation or an inquiry does not come to an end. In an investigation or inquiry, one aspect to be noted is evidence is usually collected not in the presence of the accused, but the evidence so collected behind the back of the accused is adduced in his presence during the trial of the case. See the difference? While collection of evidence is taking place behind his back, the evidence is adduced during trial in his presence. This was taken note of by a 3-judge bench in Bipin Chandra Purushottam Das Patel versus State of Gujarat, 2003, Volume 4, SEC 642, 3 judges. In fact, you may also notice that section 273 CRPC also says that evidence is to be ordinarily taken in the presence of the accused. He has a right to be present when evidence is adduced before the court during trial. Now, though the expression trial has not been defined in CRPC, the expressions like inquiry and investigation as contained in section 2G and 2H thereof have been defined, but not very satisfactorily. The word trial is clearly distinguishable from inquiry, and inquiry must always be a forerunner of trial. Rather, it is only after the conclusion of inquiry that trial can begin. That has been taken note of by the Supreme Court in 2 decisions which went from Kerala, Velavidan versus State of Kerala, 2004, Volume 1 SEC 215 corresponding to AIR 2004 Supreme Court 536, and Moli versus State of Kerala, 2004, Volume 4 SEC 584 corresponding to AIR 2004 Supreme Court 1890. But you may kindly note that this Velayudan and Moli both were overruled by a 3-judge bench on another point, not on this point, on another point, there where a sessions court takes cognizance without a committal and conducts trial without a demur by the accused. These two decisions held that trial is vitiated. That was overruled by a 3-judge bench holding that no, it is only an irregularity. The accused has no objection and he has undergone the trial without any demur, then you can't say that trial is vitiated. It's a curable irregularity. So that is Reddy Ram versus State of Madhya Pradesh, AIR 2012 Supreme Court 14853 judges. But this aspect of Moli and Velayudan, that is, inquiry is a forerunner of trial, has not been overruled. In fact, in Hardeep Singh's, in the Constitution bench in Hardeep Singh, AIR 2014 Supreme Court 1400 at para 27, Moli versus State of Kerala has been specifically upheld. This aspect of Moli. Therefore, you can't say that Moli stands overruled. It is overruled on a different point. In the case of a private complaint, pre-trial proceedings under sections 200, 201 and 202 CRPC constitute inquiry. When a private complaint is filed and the magistrate, after applying his mind, decides to proceed under chapter 15 by recording the sworn statement and then proceeds to 201 or 202, this is also inquiry on a private complaint. And then this inquiry and an inquiry under section 389 CRPC are also inquiry in the context of section 319, where an additional person can be arraigned as an accused over and above the accused already facing trial. This was observed by the Constitution bench in Hardeep Singh's case at para 117.2. Now, an inquiry under section 389 CRPC is strictly not an inquiry for all purposes. For example, dismissal of a complaint, 389 inquiry will lie. Dismissal of a complaint under section 203. Then dismissal of a complaint for failure to pay the court fee under section 204(4). There also an inquiry under 389 can be ordered. Then discharge of an accused. There also an inquiry under 389 can be ordered. But by whom? Not by the magistrate. Either by the session court or by the high court, sitting in the revisional jurisdiction. Therefore, one aspect we will have occasion to refer to this inquiry when we refer to 389 and 319 CRPC. Now, in the case investigated by the police, inquiry before a court ordinarily starts after the submission of the charge sheet. Once the charge sheet or final police report is filed before a court after investigation, then inquiry starts and it will continue till commencement of trial. That is what Hardeep Singh in paragraph 25 and 43 said. It will continue till commencement of trial. But then in para 43 itself, the Constitution bench would say that during the stages of sections 207 and 208, complying with the 207 and 208, and the stage of committal 209, there is only application of mind and not judicial application of mind. With due respect, I have my own reservations about this aspect of the statement in Hardeep Singh, because you can't say that after the inquiry has started with the filing of the charge sheet, there is a stoppage of the inquiry when it comes to 206, 207, 208, or at the time of committal. We'll have occasion to deal with that in detail.
Yep, Mr. Prem.
Now, once again, in fact, in there's one decision in which Justice Sadashivam is a party, who was also a party to the Constitution bench. That is Sajjan Kumar versus CBI, 2010 9 SCC 368, in which it was held that a magistrate inquiring into a case under section 209 CRPC is not to act as a post office, and he has to consider whether the case is fit for commitment to the court of session. If he is not to act as a post office, and if he has to consider the fitness of the case for commitment to the court of session, is he not applying his judicial mind? Then again, in paragraph 24 of Dharampal, another constitutional bench decision, Dharampal versus State of Haryana, 2014, volume 3, SCC 306, corresponding to AIR 2013 Supreme Court, 3018, 5 judges. Judgment by Justice Altamas Kabir. It has been held that it is open to the committal magistrate to disagree with the police report and issue summons to persons whose complicity has been revealed by the records and thereafter commit the case to the court of session. What else is the magistrate doing when he is doing that, when he is finding out whether other persons who have been charge sheeted or the complicity is also revealed by the records, and there he can, if he can proceed against them also, what is he doing? I have my own doubts about that. To that limit, barring that, there's no problem. Then there are two other beautiful decisions, namely State of Bihar versus Ram Naresh Pandey, 1957 Supreme Court 389, 3 judges. There is Jagannath Das, Justice Imam, and Govinda Menon. And then Rajendra Kumar Jain versus State of Special Police Establishment, AR 1980 Supreme Court 1510, by none other than Justice V.R. Krishnaiyer and Chinnappa, judgment by Justice Chinnappa, wherein the apex court held that a committal magistrate has the power to judicially apply his mind and give consent for withdrawal from prosecution, even in a case exclusively triable by a court of session. What exactly is the magistrate doing? Committal magistrate. He is applying his judicial mind to give consent for withdrawal from prosecution. This can be done even in a case triable by a court of session. Therefore, to that extent, I have some. Then another important, very interesting case, that is a 3-judge bench of the Supreme Court in Tota Venkateswarlu versus the State of Andhra Pradesh, AR 2011 Supreme Court 2900, holding that prior sanction of the central government under the proviso to section 188 CRPC is not necessary for taking cognizance of an offence committed outside India and falling under section 188. It is, in fact, this proviso says no inquiry or trial. No inquiry or trial. Taking cognizance, is it not an inquiry? When after the filing of the charge sheet, the court, we have already seen the constitutional bench ruling. When the court applies its mind to the papers, the charge sheet produced along with the charge sheet, it is inquiry. Then the 3-judge, in fact, this 3-judge bench was mechanically following an earlier 2-judge decision in Ajay Agarwal versus Union of India, to the effect that previous sanction of the central government is not necessary and even if it is necessary under section 188, such sanction could be obtained before trial begins. Before trial begins, there is an inquiry. The proviso to section 188 says no inquiry or trial. In fact, in Ajay Agarwal, this question did not arise at all. Both Justice Ramasamy as well as Justice Sahai, both judges had given separate judgments to hold that only a part of the offence was committed in Dubai. The offence was, the conspiracy was hatched in Chandigarh and the culminated also in Chandigarh. Only a part of the offence was committed in Dubai. Therefore, both the judges clearly held that section 188 is not attracted. If section 188 is not attracted, where is the question of applying the proviso to section 188? When part of the offence was, a major part of the offence was committed in India, not outside India. Therefore, it was this passing observation in Ajay Agarwal, which was followed by the 3-judge bench, to hold that even if sanction is necessary, it can be produced before trial. That means after inquiry. And what about the relevance of the word inquiry in the proviso? Courts can of course say that even though the word inquiry is used, it can only be trial. Such an interpretation can be given, but not to say that no, it can be produced before trial. This is the distinction between investigation, inquiry, and trial. Investigation, after conclusion of investigation, if it is a police investigation case, they will file a final police report. After the filing of the police report, inquiry starts before a court. If it is a private complaint, inquiry starts the moment the magistrate applies his judicial mind for the purpose of proceeding under Chapter 15. From that stage onwards, inquiry starts, and then inquiry will come to an end, as observed by this two cases from Kerala, which was approved by Hardeep Singh, that it is a forerunner of trial. After conclusion of inquiry, trial starts. These are the three areas of investigation, inquiry, and trial. I suppose I am clear to you. Yes, we'll go to question number 4.
Yes, sir. So just before going to question number 4,
yes,
regarding this question number 3, you had
yes,
referred to Dharampal's judgment. Dharampal also is a constitution-based decision of 2013. Now, sir, cognizance is taken of the offense, not of the offender. But
correct.
the Dharampal judgment,
Yes,
that decision states that cognizance of a session of an offense which is triable by a sessions can no longer be taken by a magistrate. It must be taken by the sessions judge after committed.
yes,
Right, sir? So
yes,
cognizance of a police report or a final report which is filed by the police is always taken by the magistrate. Section 191B.
exactly. Not only that, supposing the magistrate is satisfied that an offense exclusively triable by a court of session is revealed, why should he take the case on file as CP?
Exactly.
He is taking cognizance of that offense.
So the judgment of the Constitution Bench, even in Hardeep Singh,
Yes,
to the extent that it lends support to the correctness of this Constitution Bench in Dharampal,
yes,
as you said,
requires reconsideration.
one cannot agree.
Requires reconsideration. Yes, you are absolutely right.
So the fourth question is, what is the object of criminal law?
Why should there be a criminal law? What is its object? It was beautifully stated in a division bench ruling of the Kerala High Court, comprising of Justice K.T. Thomas and Justice Chatrath C. Shankaran Nair, in State of Kerala versus V Narayanan Bhaskaran, 1991 2 KLT 217, corresponding to 1991 Criminal Law Journal 238, to say that the object of criminal law is to suppress criminal enterprise and to punish the guilty. It is not only to punish the guilty, to suppress criminal enterprise also. As you all notice, the IPC does not say you shall not commit murder, you shall not commit rape. IPC does not say, Indian Penal Code does not say you shall not commit murder, you shall not commit rape. If you commit, whoever commits murder, whoever commits rape, this shall be the punishment. That's all. So the purpose of criminal law is to suppress criminal enterprise and to punish the guilty, whoever is found guilty. Beautifully stated by the division bench. Then in paragraph 9 of Harbans Singh versus State of Punjab, AR 1962, Supreme Court 439, the Supreme Court, speaking through Justice K.C. Das Gupta, probably he is the same Das Gupta who was referred to by Chief Justice Kania in R.R. Chari's case, 50 Supreme Court. It is a court's duty to convict a guilty person when the guilt is established beyond reasonable doubt, no less than it is its duty to acquit the accused when such guilt is not established. So both are the duties of the criminal court. Not to see that an innocent person is set off. Even a guilty person should be punished. That is also a duty of the court. Yes, question number 5.
My question is a continuation of what Prem asked. How is
Yes.
that object or objective achieved through criminal trial?
Yes, that object can be achieved only through a fair and impartial trial, as guaranteed by Article 21 of the Constitution of India, in which justice is done not only to the victim but also to the victim, to the accused, and also to the society at large. Society at large is also interested in the outcome of a prosecution. Ambika Prasad versus State, Delhi Administration, AR 2000, Supreme Court 718. Then again, Asha Ranjan versus State of Bihar, AR 2017, Supreme Court 1079. Again, Gopalakrishnan P. alias Dilip versus State of Kerala, AR 2020, Supreme Court, page 1. All these decisions have highlighted the fact that it has to be a fair trial, conformity with Article 21 of the Constitution of India, etc. Then another aspect is presumption of innocence and benefit of doubt. One of the cardinal principles which should always be observed in our system of administration of justice in criminal cases is that a person arraigned as an accused is presumed to be innocent until and unless found guilty by a court of competent jurisdiction. Another golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced, one pointing to the guilt and the other in favor of the accused, courts are bound to take the view favorable to the accused, provided this rider is important. On the evidence, two views should be available. Only if two views are reasonably possible, then only this principle. You may refer to Kali Ram versus State of Himachal Pradesh, AR 1973, Supreme Court 2773. In fact, this decision is also an authority for the proposition that an investigating officer, by having communications, correspondence, cannot circumvent 162, the bar under 162. Then Shionandan Paswan versus State of Bihar, AR 1983, Supreme Court 194. Again, Nishar Ali versus State of UP, AR 1957, Supreme Court 366. Then again, the beautiful observation by Viscount Simon. A judge does not preside over a criminal trial merely to see that no innocent man is punished. A judge also presides to see that a guilty man does not escape. Both are public duties of the court. As per Viscount Simon, in Stirland versus Director of Public Prosecution, 1944 appeals cases 315. This court was approved by the Supreme Court, at least in two cases, that is State of AP versus Anil Singh, AR 1988, Supreme Court 1998. Again, State of Punjab versus Karnail Singh, AR 2003, Supreme Court 3609. There may be other cases also. This beautiful proposition laid down in Stirland was noted with approval by the Supreme Court. Then in Jayalal Sahu versus State of Orissa, there is a beautiful decision by Justice Arijit Prasad, heading a division bench of the Orissa High Court, wherein his lordship has highlighted the fact that just as an innocent person should not be punished, a guilty man should not go unpunished. Both are equal, both are important. Then another aspect of fair trial is delay in completion of trial. On the question of undesirability of protraction in the prosecution and resultant trial, a constitutional bench of the Supreme Court, way back in the year 1954, observed as follows. It is undesirable that a criminal prosecution should wait till everybody concerned has forgotten all about the crime. The public interest demands that criminal justice should be swift and sure, and that the guilty are punished while the events are still fresh in public mind, and the innocent is absolved as early as consistent with a fair and impartial trial. See what beautiful statement. Criminal trial should be very swift, and both the innocent should be set free as early as possible. Likewise, the guilty person also should be punished as early as possible. When the memory is still fresh in the public mind. M.S. Sharif versus State of Madras, AR 1954, Supreme Court 397, Constitutional Bench. Judgment by Justice Vivian Bose. Then Justice V. R. Krishna also had occasion to mention about the delay in trials. Shivaji Shahabrao Bobade versus State of Maharashtra, AR 1973, Supreme Court 2622, made a pertinent observation at the opening of the judgment itself. One of the misfortunes of our criminal process, which stifles penal justice, is the counterproductive course of trial and appeal, each removing a lengthening chain. Beautifully stated. So this in fact is the basics of a criminal trial. It has to be swift, it has to be sure, and it has to be fair. It has to be fair not only to the accused, but also to the victim, but also to the society at large. Yes, we'll pass on to question number 6.
Yes, sir. When does trial start in a summary and a summons case?
Now we come to the most important part of this lecture. When does trial start in a summary and summons case? See, what is a summons case? Summons case means punishable with imprisonment for 2 years and below. Above 2 years, warrant trial. Now, in a summary trial, procedure is same as that of the summons trial, namely 262 read with section 251. 251 is the crucial section. Courts have taken the view that the trial in a summons case starts when the accused, in response to the process issued against him, either appears or is produced before the magistrate, and the substance of the accusation is stated to him by the magistrate under section 251 CRPC, and the plea of the accused is recorded under section 252 CRPC. So substance of accusation is stated to the accused by the magistrate under section 251, and the plea of the accused is recorded under section 252. Trial starts is the view taken. Thereafter, the procedure contemplated in chapter 20 CRPC has to be followed, and the trial is to be taken to its logical conclusion. Is what para 16 of Subramanian Seduraman versus State of Maharashtra 2004 volume 13 SCC 324 corresponding to AIR 2004 Supreme Court 4711, 3 judges ruling as held. Now, here I have some reservations about this statement of law. When the substance of accusation is put to the accused and his plea is taken, he has 2 options. One, I plead guilty, or I do not plead guilty. If he pleads guilty, magistrate has got some responsibility. Magistrate should be satisfied that the plea of guilt is made voluntarily made. For that, he will have to tell the accused, my dear accused, you are not bound to plead guilty. Even if you plead guilty, this is the sentence imposable on this for this offense, and don't expect any leniency from me. Therefore, even if you plead guilty, you can be sentenced to this much period of imprisonment, etc. Therefore, you don't have to plead guilty. Then, if you want to think over it, if you are under the influence of some policeman or somebody else, that if you plead guilty, you will be let off with a fine. You are thoroughly misunderstood. Don't be under such impression. And if you want to think over it, I will give you time for reflection. These are all the things which the magistrate will have to safeguard, which the magistrate will have to follow before holding that he has voluntarily pleading guilty. Now, which is the foundation for an accused pleading guilty and the court convicting him? Where do you find the foundation in the evidence law, in the law of evidence? The foundation for an accused to plead guilty and the court to convict him straight away. It's a facet of section 58. An admitted fact need not be proved. See, section 58 Evidence Act says an admitted fact need not be proved. And notwithstanding the admission, court under the proviso, court can they ask for the opposite party to prove the case, notwithstanding the admission. Therefore, it is a beautiful expansion of that principle. An accused who has committed an offense may have the guilty feeling, prick of conscience, to say that why did I committed this offense? Why should I plead not guilty? Why should I tell total absolute falsehood before court? I know that I committed this offense. He has the prick of conscience. Therefore, he is given the option to plead guilty. Only thing is, magistrate should be satisfied that he is not influenced by any other extraneous influence. Once the magistrate is satisfied, the magistrate can straightaway convict him and impose an appropriate sentence. That is the plea of guilt. Now, supposing he pleads guilty and the magistrate is satisfied that he is voluntarily pleading guilty and convicts him and imposes an appropriate sentence on him, is there a trial? Is there a trial? There is no trial. Trial can commence only when he pleads not guilty. Then only he will say that I claim to be tried. I want to be tried. If he pleads guilty and the magistrate straight away convicts him and imposes a sentence on him, there is no trial. Prosecution is not called upon to prove its case. Therefore, that aspect has not been highlighted in many of the rulings. Then we pass on to question number 7.
Question number 7. Immediately after his appearance in a summons trial case, the accused filed an application requesting the magistrate to drop the proceedings since ingredients of the alleged offence were absent in the substance of accusation proposed to be stated to him. Even though the magistrate was convinced that the ingredients of the offence were absent, he dismissed the application filed by the accused, relying on the dictum in Adalat Prasad versus Ruplal Jindal, AR 2000 Supreme Court 4674. Will the accused be able to successfully challenge the order passed by the magistrate?
Yes. See, there is some confusion arising from K.M. Matthew, which was overruled by Adalat Prasad. K.M. Matthew said, after the commencement of trial in a summons trial case, a summons case, after the commencement of trial, that is after the substance of accusation has been read over to the accused and trial has started, there is only two options before the magistrate. Conduct the trial and it will end in conviction or acquittal. These are the only options. There is no via media stoppage of the case. But K.M. Matthew said, no, you can't deny such a power to the magistrate. Of course, CRPC is silent. But then what is not prohibited can be a power which is not prohibited by the CRPC can be located in the magistrate. This is what K.M. Matthew said. In fact, overruling a decision of the Kerala High Court, K.M. Matthew said that no, even if the trial has started, the court can, in a summons trial case, drop the proceedings. Now, that was Kerala High Court had taken that different view, but Kerala High Court was overruled. Then, about 12 years or so, entire state, throughout the country, magistrates used to drop proceedings on some reason or the other, applying K.M. Matthew. Then, in Adalat Prasad, 2004, Supreme Court 4674, AR 2004, Supreme Court 4674, Adalat Prasad, the Supreme Court became wiser. They said that no, we wrongly overruled Kerala High Court because once summons trial has started with the substance of accusation being read over to the accused, the court can only complete the trial to a logical conclusion, either acquittal or conviction. There is no via media stoppage of the trial or dropping of the proceedings. That is what Adalat Prasad said and overruling K.M. Matthew. Now here what is the position? And Adalat Prasad said, once the court has issued, magistrate has issued process to the accused, the process cannot be recalled and the magistrate cannot go back to the pre-process stage, which will amount to review. That power is not there. And inherent power is also not there for the magistrate. Whereas in the case of a civil court has got inherent power under section 151. Therefore, any erroneous step taken by the civil court can be either suo moto or on application be corrected by the civil court, either by virtue of its inherent power or by virtue of its review power. Order 47, I suppose. Order 47 CPC is the provision. But such a power is not there in criminal court. Therefore, Adalat Prasad said, once after the process has been issued to the accused, if you recall the process, you are going to the pre-process stage for which there is no power. Therefore, K.M. Matthew was wrongly decided. That is what Adalat Prasad. But here, the important question is not Adalat Prasad's application of Adalat Prasad. Adala Prasad said, Subramaniam, yes, you are right. In fact, the principle which is applicable is Subramaniam Seduraman, because once this trial has started in a summons trial case with the substance of accusation being read out to the accused, once trial has started, of course, Adala Prasad will also apply, and the court has no right to stop the case via media. They have to complete the trial. But this is a case where the substance of accusation is yet to be read over. Yet to be read over. In fact, the accused is satisfying the court that the substance of accusation are absent. Substance of accusation are absent in this case. Therefore, what is it that you are going to read? Particulars of the offense, ingredients of the offense are not made out. When the ingredients of the offense are not made out, where is the question of court reading the substance of accusation? Where is the court reading the particulars of the offense? Ingredients of the offense are absent. Therefore, please don't read the ingredients of the offense against me, because the ingredients of the offense are absent in this case. Therefore, don't start the trial. Once you start the trial, Adala Prasad, Subramaniam, Seduraman, etc. will apply, and court will be helpless to drop the proceedings. Court cannot. But here is a stage when the ingredients of the offense are absent, and don't frame the don't start the trial by reading the substance of accusation, the accused. This is the in fact, such a view was taken by the Kerala High Court in Anandavel versus Food Inspector 2010 volume 3 KLT 49, corresponding to ILR 2010 3 Kerala 145, and Dr. Kamala Rajaram versus DYSP, that is a summons police charge case. This is a private complaint. The earlier case is Anandavel is a private complaint. The second one is a summons police charge summons case. That is Dr. Kamala Rajaram versus DYSP, SP of Police Rural Neyatingara, 2005 volume 3 KLT 617, corresponding to 2006 Criminal Law Journal 1447. So please note the distinction. Once trial starts in a summons trial case with the substance of accusation being read over to the accused, particulars of the offense being read over to the accused, there is no via media. Court will be helpless. Court will have to complete the trial. But once the trial has not started, Adala Prasad or Subramaniam Seduraman will not apply. The trial is yet to start. Particulars of the offense is yet to be read over to the accused. This is a case where the ingredients of the offense are absent. Therefore, please don't read the substance of accusation. Please don't start the trial is the request of the accused. Yes. I suppose I am clear.
Yes, sir. So earlier we spoke about when the trial starts. Now,
in a summons trial.
Summons trial. Now
Yes.
let us see how it starts or when it starts in a warrant case or a sessions case.
Yes. Now the following are the provisions in the CRPC pertaining to the framing of charge in warrant and session trial. Warrant trial 240, section 240 is the provision for framing charge in a police charge case, and 246 is the private complaint case, warrant trial. Then session trial is section 228 CRPC is the provision for framing of charge. Now, in paragraph 28 of Ratilal Banji Mithani, which was referred to by Hardeep Singh's constitutional bench in Hardeep Singh's case, Ratilal Banji Mithani versus State of Maharashtra, AR 1979, Supreme Court 94, 3 judges. The leading judgment is by Sarkaria, Justice Sarkaria. There is an observation in para 28. Trial in a warrant case starts with the framing of charge. Prior to it, the proceedings are only inquiry. Trial starts with the framing of charge. Prior to it, proceedings are only inquiry. Subsequently, a 4-judge bench decision in VC Shukla versus State CBI, AR 1980 Supreme Court, I think it is 4-judge, is it not, Prem?
4-judge, it's 4-judge.
80 Supreme Court 962, without reference to Ratilal Banji, made the following observation. The proceedings starting with section 238 of the code, including any discharge or framing of charge under section 239 or 240 amounts to trial. So framing of charge or discharge amount to trial. Hardeep Singh, State of Punjab, 5 judges constituted bench, speaking through Dr. Justice B.S. Chauhan, after referring to Raj Kishore Prasad, the year 1996, Supreme Court 1931, then Ratilal Banji Mitani, year 1979, Supreme Court 94, then V.C. Shukla, year 1980, Supreme Court 962, Union of India versus Madan Lal Yadav, 1996, for SEC 127, and Common Cause case, a registered society, that is year 1997, Supreme Court 1339, concluded in paragraphs 35 and 43 that trial commences with the framing of charge. Trial commences with the framing of charge. Now, in fact, after Redilal Banji Mitani and other verdicts referred to, there is the general understanding among the legal fraternity, both the bench and the bar included, including academicians, that trial in a warrant or session trial session case starts with the framing of charge. But this is really a mistaken impression about Ratilal Banji. Ratilal Banji has Justice Sarkaria has beautifully stated when does the trial start. But only one sentence has been read out of context. Rather, the readers did not go beyond that sentence. I will read that portion. Para 28. Trial in a warrant case starts with the framing of charge. Everybody read only that. Prior to it, the proceedings are only an inquiry. After the framing of charge, if the accused pleads not guilty, the magistrate is required to proceed with the trial in the manner provided in sections 254 to 258 to a logical end. 254 to 258 is under old code, corresponding to 246 to 248 of the present CRPC. Therefore, Justice Sarkaria beautifully put it. Trial starts with the framing of charge. After framing of charge, if the accused pleads not guilty, then the magistrate is required to proceed with the trial to a logical conclusion. This is the beautiful statement by Sarkaria. Unfortunately, the first sentence alone has been taken to say that trial starts with the framing of charge. Now, we will see now the sections, the CRPC. Section 242(1) CRPC is the provision for warrant trial in a police charge case. Then 246(4) is the private complaint warrant trial. 230 is the session trial. In all these sections, the section says the accused does not plead guilty or claims to be tried. Does not plead guilty and claims to be tried. Therefore, trial is yet to begin. He pleads not guilty. I am not guilty. Supposing he pleads guilty, there is no trial. Straight away the magistrate, if he is satisfied that the plea is voluntarily made, he straight away convict the accused and award the punishment. Then we will examine the logic of this argument different way also. See, if the accused voluntarily pleads guilty and magistrate is satisfied that the plea is voluntarily made, is there a trial? So just because the charge has been framed and the accused voluntarily pleads guilty, there is no trial. Charge has to be framed, plea of the accused is to be taken, and the accused should say that I don't plead guilty. I want the trial to be conducted. Then only the trial will start. Then we will examine this proposition in another way also. See, during the preliminary hearing in a case exclusively triable by a court of session, Sessions Court conducts the preliminary hearing under section 227 CRPC. And if the sessions judge is satisfied from the record, prosecution record, that is an offence exclusively triable by a court of session is not made out. What is the procedure prescribed under section 228(1)(b), 228(1)(a), I'm sorry, 228(1)(a). I will read that section for you. 228(1)(a). If after consideration and hearing as aforesaid, the judge is of opinion that there is ground for presuming that the accused has committed an offence which is not exclusively triable by a court of session, he may frame a charge against the accused and by order transfer the case for trial to the chief judicial magistrate or any other judicial magistrate. Therefore, session judge is framing the charge. If trial starts with the framing of charge, trial has started before the session judge under section 228(1)(a). If you say that trial will start with the framing of charge, trial has started before the session judge. Thereafter, can he transfer the matter to the CJM or to the judicial magistrate of first class for trial? And not only that, see the wording. And by order not exclusively trial by court, he may frame a charge against the accused and by order transfer the case for trial. Transfer the case for trial to the chief judicial magistrate or to the judicial magistrate of first class. That means he is transferring the case only for trial. Trial is yet to take place. Merely because charge has been framed, you cannot say trial has started. In fact, you may see the session judge is not taking the plea of the accused. Session judge is only framing the charge. He is not taking the plea. And can the magistrate take the plea on this charge framed by the session judge? Can the magistrate take the plea of the accused on the charge framed by the session judge? He cannot. He has not framed the charge. So the magistrate will have to frame a fresh charge and record the plea of the accused. See the beauty of the sections. See the beauty of the sections. Therefore, it is not correct to say that trial before a session court or in a warrant trial or session trial starts with the framing of charge. No, wrong. Trial can start only when the accused pleads not guilty to the charge framed against him and claims to be tried. So to sum up, I will say that a proper understanding of Ridulal Banji Mitani and the above sections 240, 246, 228 would be to indicate that after framing of charge, it is only when the accused pleads not guilty and claims to be tried that the trial can legitimately start. Am I clear?
Yes, sir.
Thank you. We pass on to question number 9.
Yes, sir. Is cognizance of an offence taken before or after the commencement of trial?
It's a simple question. When is the cognizance of an offence taken? Is it before or after the commencement of trial? It is only after cognizance taken and process issued that the accused will be summoned to the court. Accused will enter appearance. Then only the question of framing charge and commencement of trial will arise. Therefore, cognizance will always invariably precede the trial. Then question number 10.
Question number 10 is the final question.
Yes.
Why is that the stage of commencement of trial relevant in criminal proceedings?
Because I have been trying to impress upon you about the commencement of trial. When does the trial start in a summons trial? When does the trial start in a warrant trial? When does the trial start in a session trial, etc.? Why, you might have been wondering why this man is after all about the commencement of trial. But the commencement of trial has some meaning in certain proceedings. One, for example, recording of confession or statement under section 164 CRPC cannot be done after the commencement of trial. Likewise, holding of a test identification parade, TIP, cannot be done after the commencement of trial. So the commencement of trial assumes importance. Then thirdly, there cannot be any inquiry or trial without the previous sanction of the central government in a case covered by section 188 of the CRPC, where an offence has been committed outside India, in view of the prohibition under the proviso to section 188 CRPC. Therefore, there also commencement of inquiry or trial is relevant. There I have already stated before you that Tota Venkateswarlu case, where it was held that it is enough that the sanction is produced before commencement of trial. That is after inquiry. Can it be done? Is my question. Then the fourth situation is session judge cannot withdraw or recall a case which he had made over to the additional session judge after the commencement of trial before the additional session court. If you read section 409(2), subsection 2 of section 409, once the session judge makes over a case, say a session case for trial to the additional session court, and the additional session court has framed the charge and taken the plea and trial has started, the session judge cannot withdraw the case to himself by virtue of the bar under section 409(2) CRPC. But there is one decision of the Kerala High Court Division Bench, Kumar versus Vijayan, 2005, 4 KLTs 475. This bar will not apply if the session judge were to transfer the case from the additional session court to any other to the session court. What you cannot do directly is sought to be indirectly achieved through this ruling. I don't know how far it is true or not. Anyway, I leave it to the floor for discussion. In fact, that decision says, irrespective of the stage of the case, the session judge can transfer the case under section 408 in gross violation of section 409(2). Anyway, then the power under section 319 CRPC for adding an accused person can be exercised only when there is evidence. Evidence, which means evidence brought out during trial. That is what Hardeep Singh's constituted bench in Hardeep Singh's case held. The power under 319 can be exercised only when there is evidence brought out during trial. Section says evidence during inquiry or trial. So how to explain inquiry? The word inquiry occurring in section 319(1) CRPC takes in inquiry under section 200, 201, 202 and 398 CRPC, and the materials coming before court during such inquiry can be used only for corroboration. This is what the constituent said. Can be used, it is not evidence, can be used for corroboration when the actual evidence is recorded during trial. That is what Hardeep Singh held in to constitutional bench ruling. I have already given citation. Year 2014 Supreme Court, 1400, 5 judges. But then, what has been held in para 108 of Hardeep Singh is that a person discharged earlier can be arraigned as an accused under section 319 only after conducting an inquiry under section 305, subsection 5 of section 300 and section 398 CRPC, and during such inquiry there is evidence against such a person. Section 300 clause 5 takes in only a discharge under section 258 CRPC, not any other discharge. There are other instances of discharge under section 239, 245, 227, etc. That is not taken in by section 305. Again, secondly, how can a magistrate who has already discharged an accused conduct an inquiry under section 398? 398 is a revisional power of the session judge or the High Court. I don't know. I am leaving it to the floor for discussion. With that, I think we have covered this aspect of trial, inquiry, and investigation. Thank you for hearing.
You were the, as I say, just like master of the roster, you have framed the questions. You covered every aspect. But and rest of the people can't even claim that they are equal.
No, I don't claim to be all knowing. I only to the best of my knowledge, information, and belief. That's all.
We can only
like
say
to give an effort.
Humility at its best.
Yes.
Sir, we have 3 questions so far.
Yes.
One is by Mr. Iyer. When can a trial be started against the accused if accused has been closed? If case has been closed on the closure report by the investigation agency, whether police can suo motu restart the investigation and arrest the accused in such a case?
Ordinarily, no. Because once there's a closure report is filed, as held in 1985, so Bhagavan Singh, etc., starting from 85 Supreme Court onwards, not only the police, but also the court is bound to give notice to the first informant. First informant is entitled to notice. And after notice, he can either object to the case being dropped or he can file a protest complaint. And if cognizance is taken on the protest complaint, when the case comes up for trial, trial again can start on a protest complaint. That is the well accepted principle.
Second by Naveen Kumar. When the case is posted for evidence before recording the plea after framing charges, can that order be recalled or can a discharge application be filed upon the ground that evidence is yet to be started?
In 1992, Supreme Court said once a plea plea of not guilty is taken and trial has started, the court can allow him to plead guilty. But actually, the 92 is the year in which K.M. Matthew was decided. But K.M. Matthew was overruled in Adalat Prasad. If strictly applying Adalat Prasad, the criminal court cannot go back to the pre-trial stage, pre-plea stage, and allow his plea. Technically, it's not possible. But anyway, 92 Supreme Court has stayed as not been overruled so far. And following 92 Supreme Court, Kerala High Court has also taken the view that notwithstanding the plea of not guilty, he can be allowed to plead guilty. But I don't think if you strictly apply Adalat Prasad, the criminal court has no power of review or inherent power. Therefore, he cannot go back to the previous stage. Am I right, Mr. Prem?
But sir, of course, Adalat Prasad and of course, Setu Subramaniam. But at the same time, during 2012, there's a decision by the Supreme Court. I think it is by Justice Sadashivam and Justice Charameshwar. Bhushan Kumar versus NCT of Delhi.
Yes.
That is 2012, Volume 5, SEC, page 424.
Yes.
Which rules that a magistrate has the power to discharge an accused even in a summons case. It says that it is inherent under Section 251 CRPC that if an accused he appears before the court, before the trial court, in persons of the summons which is issued under Section 204, it is the bound and duty of the trial court to first carefully go through the allegations made.
Exactly.
And then, if it is not in the affirmative, the magistrate, he can discharge. He is bound to discharge the accused as per Section 239.
After reading the substance of accusation.
No, if no substance read out.
Yeah, that is what I said. Anandavel. Anandavel is that principle. That is, you don't start the trial. You don't commence the trial. You tell him. Or accused can in fact tell the court that the ingredients of the offence are not made out. Therefore, don't start the trial. Then you don't call it discharge. You drop the proceedings.
No, so it's not that like that. The magistrate explains the substances.
Then trial. Then going by Subramaniam, that Subramaniam Seduraman, trial has started.
Exactly, because there were 3 judge rulings and this is a 2-judge decision.
Yes. That is the problem with our Supreme Court. You have any number of conflicting decisions by Supreme Court on almost every point in criminal law.
And actually this Bhushan Kumar, if you go deep into Bhushan Kumar, it was in fact Section 420 IPC was in play. So in fact, it's a warrant case and not a summons case. And it was decided as if it's a summons case.
What is the difference between confession and pleading guilty?
That is a judicial confession. Pleading guilty is a judicial confession taking place inside the court. Confession can take place outside the court, extrajudicial confession. Pleading guilty is an instance of judicial confession. Clear?
Umesh Gandhi, on the basis of protest petition or otherwise, whether the magistrate can summon the accused not charge sheeted but named in the FIR regarding offences exclusively triable by the Court of Sessions.
I didn't get the question.
So on the basis of a protest petition or otherwise, whether the magistrate can summon the accused not charge sheeted but named in the FIR regarding offences exclusively triable by a Court of Session.
That is what is that? Not Hardeep Singh, the other one. What is that? Constitutional bench. Dharampal. Dharampal held so. Magistrate has got the power to proceed against a person not charge sheeted, but whose complicity is revealed by the police records. That should be there. If his complicity is revealed by the police records, he can issue summons and get him and then commit him to the court of session.
So the last question, can a plea and 311 statement be recorded together in a summons case? What is the effect if recorded together?
Plea and 311. 311 is additional evidence or further material. Plea and 311 have no parallel, nothing in common. I didn't get the question.
It's fine. So we can end up the session, and as usual, we will this time request Mr. Menon to complete it. A formal vote of thanks.
Now, we have been told in detail what exactly is trial and what is the significance of the word trial. Because as we see, since the very ancient civilization itself, our criminal laws have been distinctive for uniquely serious potential consequences for the failure to abide by the law of a specific culture or any region. The whole world you can see. And of course, exceptions are the rule of a monarch or a dictator, or elsewhere it can be even a communist rule. Otherwise, every society, every crime that is one against a society. So we should have certain laws, and the criminal laws, it is so designed because it is put inside a particular kind of procedure, because it is for the courts to exercise or to implement these laws through the procedure which is established by law, as we see. And this is what the criminal procedure code serves as a vehicle for implementing criminal justice. And today we have been enlightened. All of us have been enlightened by Justice Ramkumar, who has taken us through the nuances of criminal trial. Now, what the CRPC contemplates and at which stage the trial commences, what are the judgments, starting with the Privy Council judgment and ending with the latest Supreme Court judgment, and also pointing out the deficiencies of some of the Supreme Court judges, judgments, like Hardeep Singh of 2014. So that is absolutely wonderful, because when you are in play, we can see that you are a complete judge, and all your judgments reflect the completeness of what a judicial officer should be. And with your sort of commitment and an in-depth knowledge, we have been able to understand what exactly are the nuances of this particular field of law. Thank you so much, sir. It was absolutely erudite and enlightening.
Now, before parting, shall I ask one question to all? Don't you feel that the criminal court also should have inherent power and a power of review? So you mean that I mean the magistrates and session judges for doing justice?
Sir, it's already there, because to recall, Adalat Prasad has not considered certain judgments. Take it this way: a criminal court does a wrong, patent wrong, like summoning a person, if it is patently wrong. Now, it is not wise to say that the criminal court does not have the power to recall. See, if you see the judgment in Satyam Fibers versus Indian Bank, which bases upon certain old English judgments, it says any court, whether civil or criminal, is having the inherent power, because here comes the dictum, the legal maxim, actus curiae neminem gravavi.
That is so. But then,
what was wrong, the court has the power to undo the wrong.
What about section 460, 461, 465, etc.?
Absolutely.
When without jurisdiction something is being done, it is for the superior court to rectify that, is it not? Can the wrongdoing court itself rectify the mistake?
But at the same time, sir, except for you can see, of course, the power to review, it is not there. But the power of review and the power of recall, they are extremely different.
That is so.
That is the aspect, because review is a separate power, recall is a separate power.
That is so. Recall is a judgment of law.
Exactly.
Review is a statutory power.
So
Unless conferred, there is no power of review. Unless expressly conferred, there is no power of review.
Correct,
Recall
sir.
is a judgment law.
Correct, sir. But at the same time, yes, Mr. Rao, you can.
No, sorry. You
No,
continue.
you can just go on.
No, like sometimes what happens is the magistrate passes the order. The police are refusing to act on
Implement.
that order, saying
Implement.
yes, saying that this is a technicality. The judge, the magistrate did not mention this. Now, if the magistrate now cannot recall that order, and then we are stuck. So now you are forcing me to go for review for something that doesn't exist.
Or
Because
it may be a case of civil contempt. Civil contempt. Not disregarding violating an order of court.
Of court, correct. But then it is lengthening the process of the proceedings that which the police has no powers in the first place. You see, so
No,
action,
in the hands of an unscrupulous police officer, nobody is safe.
true. I agree with you, sir. Thank you, sir.
And at the same time, sir, if you see the 3 judges bench rulings in Adalat Prasad as well as in the Subramaniam Cheturaman,
Yes.
both the judgments would say that if the magistrate issues a process even without a basis, the only remedy is under 482. How can that be only under 482? There are other remedies. Even 227 can be, 226, 227.
397.
397, anything can be.
397. Yeah.
I think Adalat Prasad to that extent, Adalat Prasad and Subramaniam Cheturaman to that extent needs to be reconsidered, and that Matthew has to be brought in. Needs to be revisited.
Sir,
But Matthew was startling. And what happened throughout the country? Magistrates were indiscriminately dropping proceedings. That should not happen. It should be at the cost of justice.
But at the same time, sir, when Adalat Prasad says your remedy is under 482, there are constitutional bench decisions, numerous, saying that 482 should be exercised only sparingly and that too in the rare case.
And but then, of course, that will not foreclose a relief and a remedy under 397 or 226 or 227, etc. 227 also, Article 227 also will be there. Just because Supreme Court said 482, that is the only remedy, you can't say that no other remedy is available.
Now we have the patient resurfacing case also, wherein the court goes on to hold that.
Yes.
So there was one question that if sanction has not been obtained under 197, will the trial be vitiated?
Trial will not, in fact, it can be raised at any stage is the question. In fact, to that extent, Adalat Prasad may be wrong. Suppose Adalat Prasad and Subramaniam Cheturaman says, once trial has started, court has no other function except to complete the trial. But supposing prosecution sanction is raised, very same Supreme Court has said that it can be raised at any stage.
Any stage, correct, sir. Yes, that I agree with you, sir.
But then it is not a total nullity. It's not nullity. Trial without a sanction, of course, it is a nullity. In fact,
it might be remanded back to the trial after
but then sanction. There's no acquittal. Once prosecution has been conducted without a prosecution sanction, it is a nullity, but that doesn't end in acquittal of the accused. It can only discharge or dropping of the proceedings. So that it will not preclude a further trial with sanction.
Correct.
But in one case, Supreme Court acquitted the accused for want of prosecution sanction, which is not correct.
Over to you, Vikas.
So we had a session wherein, like Mr. Prem has said, that we have understood what is trial and sessions, warrants, everything we have covered, including the investigation, trial, as well as the inquiry. The 10 questions have covered the entire gamut of the principles of trials and what could be the facets of that. And thank you, friends, for joining us. And again, we will request, keep on maintaining the social distancing, do vaccination, and wear your mask. That is a paramount, though it sometimes looks like it is a monotonous that time and again saying that, but we have seen that all these things are bringing effects.
Nobody, including you, is wearing the mask.
So we are all ensconced in our houses. This is in public places. Only in public places.
Even in the offices, nobody is there. So it's as good as self-isolation.
Absolutely.
Yeah. So, and tomorrow the session would be substantive law and procedural law, interstate relatability by Justice S.D. Anand, former judge of Punjab Haryana High Court. Do connect with us at 4 p.m. And today there's a session, tweet or not to tweet, by Sajan Poya at 6 p.m. by Daksha Legal. Those who want to join, they can connect on the Daksha Legal platform. Thank you, everyone. Stay safe, stay blessed. Sir, thank you for your insights. Thank you. And thank you, Mr. Prem, Shyam, and Mr. KJ Rao to take things in the right way. Thank you. Namaskar.